Bueno, ¿sí? Bueno, vamos a dar inicio.
Okay, good evening. Let's kick off this roundtable. My name is Lucia Losovis. I'm in charge of children's policies at UNICEF in Spain. It's a pleasure for me to be here with you today. We called this session Reimagining Justice for Children Agenda, and on behalf of UNICEF I'd like to thank all the participants, all the expert speakers, and those of you who are following this event either in person or online. We do have a simultaneous translation service available into Spanish, English, French, and Arabic, so please help yourselves to a headset if you need it. For UNICEF, it is an honor to take part in this Congress, to share our international experience and generate access to fair and equal justice for all, especially children. Yesterday, one of the children said that real justice can only be achieved if children are granted all of their rights. So that's the takeaway message from them, from our children. And it is something really that we should bear in mind, certainly today and tomorrow, but also in general, when later on during the week we get back to the office. So this is a means to an end, justice, enabling children to enjoy a whole host of other rights as well. In today's session, we'll be, again, sharing our experiences about how we are reimagining justice. We'll be sharing our toolkits, the products we've put together, and we'll be sharing with you the press releases we've knocked together, all of us, from all UN agencies for this purpose. I'd like to kick off this session by asking Blanca Yanez from ACID. She's an ACID representative at the EU. I'd like to ask Blanca Yanez to join me on stage to take the floor. At the lectern, please.
Estimados colegas, amigos y
friends, it is a pleasure for me to be here today at this Congress, Justice with Children, held in Madrid. I'm here to represent the Spanish delegation, and yesterday the Minister for Youth as well as the Secretary of State for Development both said that Spain is strongly committed to respecting children's right. And this, I think, has been shown by how Spain cooperates with other countries internationally. It fully reflects it. Adapting justice to children is fundamental to prevent and provide an answer to the various and multiple forms of violence that children and teenagers suffer worldwide. In Spain, we believe this justice cannot be sustainable unless it takes heed of the voices of children, their needs, their rights to participate actively in all processes which affect them. There can be no development if children are left out in the cold, and that's why we're particularly happy that this Congress is being held in Madrid. It allows us to take part in it from a number of different vantage points. And of course, we're here with our allies such as UNICEF. We collaborate with them on projects regarding digitization, social inclusion, protecting children from violence, and so much more. So it's a privilege to be here, and it's been a privilege to take part in the Reimagine Justice for Children agenda, an initiative launched in 2021 by UNICEF, with which the Spanish Agency for International Cooperation has been partnering up. Through this, we have made a commitment to the future of children, and a fair justice system to children is fundamental in all societies, and reimagining justice is something we need to do so that boys, girls, and teenagers the world over can break free of certain justice systems that aren't designed exactly to protect their rights, and when they do, there are devastating consequences for them and society alike. We from ACID believe that a child-centered justice is not a luxury, it's something we need if we truly want to make our society sustainable. There are three pillars to our initiatives. On the one hand, institutional strengthening by building skills for justice operators so that they can prioritize the interests of children in what they do. Two, by providing creative, innovative solutions which can avoid judicialization and offer constructive alternatives. And finally, by cooperating with children, making sure that the voices of children and teenagers are heard in all processes which affect them. So here today we want to launch a call to action so that all actors involved, including public actors and private actors and companies, build a more inclusive society. ACID is proud of being part of this journey and renews its commitment to backing initiatives such as Reimagine Justice, which have a real impact on the lives of children and teenagers in vulnerable situations. Thank you very much.
Muchas gracias, Blanca. Muchas gracias a la ESID por todo.
Thank you, Blanca, and thank you to ACID for all the support it provides to UNICEF. I'd like to give the floor to the Swedish ambassador now, Ms. Haline, one of the main collaborators of UNICEF along these lines. Thank you very much.
Good afternoon, everyone. Buenas tardes, distinguished guests. On behalf of the Swedish government, I'm very pleased to join UNICEF, ACID, and all of you here in Madrid, and those online to the parallel session on operationalizing the Reimagine Justice for Children agenda. The Swedish government is very honored to accompany UNICEF on this journey. The Swedish International Development Cooperation Agency, SIDA, joined the consultations on the development of the agenda 5 years ago at the height of the pandemic. SIDA has been supporting UNICEF in its mission of strengthening specialized justice systems for children and ensuring all children have access to justice for several years now. We have also joined UNICEF in many of its countries' missions and saw for ourselves the progress made as well as challenges and opportunities, why we think this work must continue. The Reimagine Justice for Children agenda builds upon lessons learned from over 160 countries, experience from the pandemic and the 2019 global study on children deprived of liberty, which includes children deprived of liberty in all its forms. This agenda not only reinforces states' accountability for the human rights of children, but also recognizes that we all have a role to play, an individual accountability, to drive progress and achieve much-needed justice reform. Central to the Reimagine Justice for Children agenda is non-discrimination. This agenda has been integrated into the Secretary General's Rule of Law vision and the EU Parliament resolution on the situation of children deprived of liberty. As we approach the 4th year since the Reimagine Justice agenda was launched, I would like to congratulate UNICEF and all the countries that joined the call to strengthen children's access to justice and protect children from detention. Thank you. Okay. This is better. The result in 2024 report card and the data that will be launched today show remarkable progress, but we also know that there is much more to be done. I would also like to praise UNICEF for its remarkable work on the Toolkit for Reimagine Justice for Children agenda. This toolkit documents promising practices, proven solutions, and strategies to operationalize the agenda. The objective of Sweden's development cooperation is also to alleviate poverty and reduce oppression in developing countries. Following a change of government in 2022, a reform agenda for Sweden's development cooperation was launched. reconfirming the overarching objective and outlining six thematic priorities, including promoting freedom and fighting oppression. Early this year, a renewed strategy for Sweden's multilateral cooperation was also adopted. It directly guides the Swedish Ministry of Foreign Affairs in its dealing with the UN and other multilateral organizations. The strategy also confirms that we will continue to operate in partnership with, for example, UNICEF, based on the SDG agenda through a human rights-based approach and with conflict sensitivity. One of the specific strategies that SIDA implements is the strategy for Sweden's global development cooperation for democracy, human rights and rule of law. Through this strategy, with an annual budget of nearly $100 million, we partner with CSOs, multilateral and intergovernmental organizations to ensure that our common international human rights system is maintained, especially for unprotected groups like children, including children in the justice system. We also support the rule of law, independence of judiciary, safety and security of the actors in the justice system, accountability and freedom from corruption. Sweden has been a long-standing partner to UNICEF in the area of child protection. With SIDA's flexible support, UNICEF is able to carry out the work it has been mandated to do by the UN member states and in line with the UN Convention on the Rights of the Child. This includes critical child protection systems strengthening efforts such as improving access to justice for children, an area that unfortunately receives limited support from other donors. We hope that many more will join us in this fulfilling but difficult mission to ensure that every child has access to justice. Thank you.
Muchas gracias, Johanna.
Thank you very much, SIDA, for all the support. Now we will give the floor to Shima Sengupta. She's the Global Director of Children's Protection at UNICEF, and she's going to present the global data, the brief note, and the toolkit as well. All the materials are in English. We will have translation into Spanish in the short term, but so far we just have the documents available in English. Thank you very much.
Good afternoon to everyone in the room, and good morning, good evening to those who are joining us online. It's a very exciting afternoon. You're all very quiet because you didn't get coffee, but it is an exciting afternoon because we're going to launch, as you've heard from yesterday, our global products on justice for children. And I do want to start by first profusely thanking the Spanish and the Swedish governments, who are represented here by Blanca and Johanna today, for their support to our work on Justice for Children programming. You heard from both Blanca and Johanna that this is a fulfilling area of work to support, but it is really an area of work that unfortunately we haven't had much interest from partners. So even more grateful to the governments of Spain and Sweden for their support, for believing in what this agenda is, and for helping us work through it and deliver in so many countries. So big thank you. As both of them have mentioned, they were also with us when we started the development of the Reimagine Justice for Children agenda. And this was 4 years ago. And the 4 years actually does not seem like such a long time. But honestly, the world has changed a lot in the last 4 years. And we've heard of all the things, right? Yesterday about Gaza and the kids in Gaza and Sudan and Myanmar all over again and Ukraine. And so it's just, if anything, become a more difficult and a more challenging place for children, and a place where children need justice more than ever. So I think it's really fitting that we have both of them in this room as we launch a report of what has been achieved so far in the countries where UNICEF supports justice programming, some of which a lot of which were also through their support. So a snapshot of our results you will be able to find in the 2-page Reimagine Justice for Children report card, where when you look at it, you will see a map of specialized justice systems for children and the remarkable increase in the number of countries providing legal aid, providing specialized child-friendly investigation, prosecution, and adjudication, as well as multidisciplinary approaches to respond to cases of violence against children. So there has been progress. Some of you were in the plenary yesterday when I spoke, and others have spoken since then. And these are the key determinants of that agenda. So when you look at the report card, you will see the numbers on this, and this actually indicates that there has been progress. We are also very, very proud to report that in 102 countries, at least 61% of all children in conflict with the law received diversion and non-custodial measures in 2024. That's a big increase from 2018 when it was at 40%. So it is. When you look at the numbers, you think maybe small, but actually it is quite a lot of work. Since this agenda was launched, UNICEF has actually been publishing annual data on the rate of children in detention in the administration of justice. And while the devastating impact of even one day in detention and incarceration on a child's physical, emotional, and mental development is now widely recognized, the actual number of children deprived of liberty in all contexts in many countries is, as I said yesterday, unknown due to incomplete record keeping and underdeveloped administrative data systems. So honestly, what you see is the tip of the iceberg. And I talked about invisibility yesterday, and there is also that factor of invisibility. So without good data on children deprived of liberty, it is impossible to understand the extent to which children are exposed to different forms of detention and to effectively monitor and evaluate the impact of related policies and programs. The data brief that we are launching today presents updated global and regional estimates of children deprived of liberty in the administration of justice based on the latest available country-level data. So it's data that we get from countries, from governments as they generate it. Data are drawn from UNICEF Global Database, based primarily on administrative records of the countries, from the governments, from the ministries who are mandated to oversee the justice systems. And these include ministries of justice, home affairs, global affairs. So in different countries, it's a combination. In some countries, it's one straight. But this is what we use to launch the data. What do we have? What are we seeing in this data? What are the big numbers we should leave the room with? Globally, an estimated 259,000 children were in detention on any given day in 2024. That is more than 250,000 children in detention on any given day. And knowing the impact of even one day of detention, this is really unacceptable, isn't it? There's so much more that we have to do. Worldwide, 15 per 100,000 children were deprived of their liberty in 2024. North America had the highest rate of children in detention at 34 per 100,000, followed by Latin America and the Caribbean at 26 per 100,000, and South Asia at 24. You know, I've always worked in countries where the development status has been poor or they have been in humanitarian conflict, and I always had numbers where they were the highest number, but that means worst from the bottom. But now I'm based in New York. And again, I'm reading data where the region that I'm based in has the worst record. And again, that is unexpected, right? The good news, of course, there's always some good news, because if there wasn't, none of us would be in this room. We wouldn't be motivated to continue our work. The good news is that there are an estimated 67,000 fewer children in detention today than they were in 2018. So the numbers are huge, but we have seen progress. All to say that if we continue in this train, we will get to zero at some point. And this is the first time that we have seen this trend data available. So hopefully from now on, we will be able to see it, but also to see the progressive reduction. Regions like East Asia and the Pacific, Latin America and the Caribbean, and North America have seen notable declines in both the rate and the number of children in detention, despite the fact that the latter two regions still have the highest rates of child detention. Another good news is that for the very first time, a UN joint advocacy brief on children deprived of liberty, the advocacy brief, is adopted, showing for the first time a common position of various UN agencies on deprivations of liberty of children in administrative justice. And all of you who do this work in various countries, across various ministries and various government institutions, you know that this isn't easy. Because even when you sit with an interministerial group, you know that they don't always agree. It is quite tough. And so for the UN agencies who work with these different line ministries for the first time to come together, I think it is a very big achievement. With UNICEF as the pen holder, the United Nations Task Force on Children Deprived of Liberty is coordinated by the Special Representative of Secretary General on Violence Against Children, Najat, who has been in various sessions and is currently here, with the Special Representative of the Secretary General on Children and Armed Conflict, the Secretary General Office on the Rule of Law, the Committee on the Rights of the Child, the International Organization for Migration, the Office of, I will just give you the acronyms, it's too many, the UNHCR, the OHCHR, the UNODC, WHO, and other members. I would take 10 minutes just to read all those names. The joint advocacy presents the rights, economic, and scientific arguments why detention is harmful, why it is costly and ineffective in reducing crimes, and shows promising practices from different countries, some of which we will hear from later when they join us here. Finally, we are launching a package of Reimagine Justice for Children technical briefs composed of not one, but 10 topics, showing promising practices of every component of the agenda and other pressing justice issues, such as children whose parents or primary caregivers are deprived of liberty. And this one is a tough one. I remember even when I was reading it, in the final, where everyone had come in and they thought it was the final draft, I still had a point, because it is a very, how do you determine what is the best interest of the child in such circumstances? Because the parents or the primary caregivers are away in prison or somewhere, and these children become very, very invisible, and they're not even counted. Because even if they are with their caregivers in prison, they're not counted as being in prison. So it really was a tough one, and it was very challenging to determine, but we did get there, and I hope it will be useful for everyone. Another difficult topic was the one on armed violence, where children involved with these groups are often excluded in the application of child or juvenile justice laws. And we are often having to come back to remind governments that they need to be included, that they should not be looked at as perpetrators. Then there's the critical role of mental health and psychosocial support, as well as the social service workforce in the justice system, which are also outlined for child victims, for those in conflict with law, and for those who are involved in civil proceedings. For those of you who were in the plenary yesterday, you remember Melody's story, and where she said she felt, even though she was the witness, but she felt invisible, unheard. Nobody was asking her what was she going through. Another issue that has been challenging, we find in many circumstances, is setting up legal aid. So we have a technical brief on how to set up legal aid, because this is critical for every child, no matter what right is involved to access justice and effective remedies. Since in many countries, many people seek justice outside the formal courts and customary justice systems, and because customary justice systems are close to the people, culturally resonant and locally legitimate, a paper on customary justice for children outlines how it can be nurtured to protect child rights. This paper will also be presented in the upcoming World Justice Forum in Poland on the 27th of June. By that time, the technical notes on access to justice for child victims and children in civil proceedings, child-friendly courts and proceedings, and legal empowerment and justice for children will also be available. So in total, there will be 10. We hope that these technical notes will be very useful, not to keep on your shelf and look beautiful, but they will actually be useful as you strive every day to make the justice system a real refuge for children, so that children are able to claim their rights. We talked about it yesterday, that they should be aware of their rights and they should be able to express and claim their rights. And you yourself, a defender of those rights if they're violated. I hope you will be inspired by the sharing of some of the countries that have been documented in these technical guidance, but also as you listen to some of them. We have invited them here to share both the challenges that they faced as well as the opportunities that they leverage, rather than merely hearing the normative standards. We hope that you could also share some of your challenges and good practices during the discussion. And together we build a community of practice, a community of champions on justice for children. And when you leave the room, you leave better informed and more motivated to do more. Thank you.
Muchas gracias, Shima.
Thank you very much, Shima. All the materials are available on the UNICEF website, so you can download them. They are in English. Wonderful job, so congratulations to the team. Now I will give the floor to my colleague, Grace Akayoli. She's a technical head of technical team in Justice with Children, and she's going to moderate the panel. We are going to listen to certain experiences, and we're going to try and understand how the Reimagine Justice for Children agenda is being implemented in different countries, and what have we achieved. Thank you very much. You have the floor, Grace. Thank you very much. I'm going to speak both in Spanish and English. Well, I think we're all very excited, right? After listening to what Shima had to say. Are you excited or not? I need to feel the excitement, right? We are all very excited, very inspired. We can keep fighting for children's justice. I would like to thank all my colleagues in ICID as well. And now I will call to the stand our other colleagues that have been working on this. So Natasha Ryan, Child Protection Officer. So now I'll speak in English.
In Southern Africa, she will present the study that was documented on this first UN joint advocacy brief on deprivation of liberty in the administration of justice, or what we call normally as children in conflict with the law, or children who are accused of, charged, or convicted of a criminal offense. I will also call now the other panelists. We have with us also our colleague from Spain. Of course, Spain, our host, has good practices to show us as well. Dr. Eva Bajo will join us and represent the good practice from Spain. And we have from Eastern and Southern Africa. We traveled all the way to our host country. We traveled here now to Madrid. We traveled to our neighboring European and Central Asia countries. We have with us a representative from Bulgaria, Nelly Petrova Dimitrova from the Social Activities and Practices Institute, who will join me on my right hand. And finally, we have with us a former Minister of Justice and presently the Coordinator for Judicial and Legal Reform in Timor-Leste, the region where I came from, Eastern and the Pacific, Eastern Asia and the Pacific, Madame Lucia Lobato. Thank you. Let's give them a round of applause, please, because you see, they came from all the way from Timor-Leste, Bulgaria, and neighbors, Spain, maybe here, and of course, Europe, from Bangladesh, although she's representing the study that she made in Eastern and Southern Africa. México también, perdona. Claro que sí, perdón. Estoy hablando. Finalmente, claro, nuestra colega que está representando los países en México, ahora estoy hablando en español, en Latinoamérica y Caribe, nuestra colega María Elisa Franco Martín del campo de una universidad que se llama UNIUNA, Bruselas. Qué pena con ustedes, es por casualidad que somos todos mujeres.
So we are all women. Is it by chance? All our colleagues, also moderators, we are all women, so it's good, and we are all together.
On our colleague Natasha Ryan, who will speak to us about a study in the region Eastern and Southern Africa. This is widely documented in this first UN Task Force Advocacy Brief on Deprivation of Liberty in the Justice System. It follows an earlier study that was done in another region, which is Eastern Asia and the Pacific. So it's a regional study that actually documents the good practices on diversion and non-custodial measures. Because sometimes some of our colleagues, counterparts would say, do we have to travel to faraway places? Do they exist in countries that are also low and middle income, as well as high income countries? Natasha, can you tell us about what is diversion? We think that we all know what diversion is, but in our study we found out that there's different interpretation of diversion. And why is it a critical component of the criminal justice system?
Thank you so much, and good afternoon, everyone. Well, in an effort to keep that number at 0, as just presented by Shima, diversion is a really critical component of the criminal justice system to keep children away from that system. We know that nothing good comes of children being in contact with it. It is a decision that can be made by a justice actor as per the Convention on the Rights of the Child and the committee and the jurisprudence coming out of it. It can be a decision made by several justice actors, but as we can see, as we saw in our study, how this is interpreted depends on the jurisdiction. So it can be the police or prosecution or the judiciary that makes a decision that this case involves a child or an offense that shouldn't have to go through the justice system, where we are talking about children who have already reached the minimum age of criminal responsibility. There are some prerequisites. A child must accept responsibility, not an admission of guilt, but accept responsibility for the incident that has happened and be willing to go through some kind of diversion measure. It may be a written apology to the victim. It may be continuing education. It may be some form of being a service to the community, but a measure that they are happy to go through as they take responsibility for the incident. And it's really about rehabilitation. As we've heard many times in the last 2 days, moving away from a punitive system to a rehabilitative one. And this is really key to keeping children out of a system that was not designed for them.
Thank you, Natasha. And you have looked at the use of diversion in 10 sub-Saharan countries. What good practices can you point to and the trends that you have found on this study?
Thank you so much. And absolutely, we see diversion being used very effectively in many of the countries we studied. 10 sub-Saharan African countries that we looked at, and really taking on the jurisprudence and the spirit by which the Convention of the Rights of the Child was drafted and the subsequent guidance that has come out. We see that South Africa and Kenya emerge as leaders in terms of regulation, in terms of a strong framework for diversion that is both backed up in legislation, but also in implementation and full national coverage. We see that Tanzania allows diversion also for serious offences, very much in line with the guidance by the Committee of the Rights of the Child. Often diversion is seen by justice actors as something only relevant to petty offences, but in fact it can and should also be used for serious offences. As we know, harsh punishments does not necessarily mean and will not lead to that child being rehabilitated. We see that Malawi allows for diversion for repeat offences. So often diversion is talked about as a second chance for a child. But in fact, those second chances can be a third or a fourth chance. And we see Malawi really keeping that spirit as well. In some cases, like Zimbabwe, we see good practices of diversion first being piloted, where you have a proof of concept that it's possible in a particular district, perhaps supported by UNICEF or NGOs, and then eventually taken on board by the government directly and scaled. And we see that increased national coverage of a diversion program and legal and regulatory frameworks following. So it doesn't always have to be that law comes first. We can get the proof of concept and then make sure that there's strong legal basis for it as well. We see that each system, depending on, of course, if it's civil or a common law system, places different emphasis on the particular actor that is empowered to carry out diversion. So, for example, in South Africa, there's a strong focus on prosecution. In Zimbabwe, a strong focus on police. And in Somaliland, for example, a strong focus on the judge. So this will really come down to the legal culture in that particular country. But the advice and the guidance from the committee is that every actor should be empowered to carry out diversion, and it should not be once the case has already come to the judge for judgment. I'll stop there on that one.
And for my last question to you, Natasha, how do you think we can strengthen good practices in line with the recommendations of the Committee on the Rights of the Child?
We know that where there is strong political will and investment in children's rights and a budget that is allocated for children's rights, that's where we see diversion mechanisms and other social protection mechanisms that have a focus on rehabilitation do really well. Where systems have moved away from a punitive culture, often inherited in many of these jurisdictions, to rehabilitative, and where there's public support for the principles of the ideas of restorative justice and not that punitive system, and reintegration into community. These children are often very stigmatized, and so where there is strong community support for reintegration into society, that's where we see that this does really well. It is ultimately a question of investment of public funds, and where we see that there is an investment in a social protection system that puts children first, that's where we see the stronger provisions for implementation of the spirit of the Convention.
Thank you very much, Natasha. I'm sure you have a lot of questions, but I think we have some key messages from Natasha here. Normally, we think that diversion, non-custodial measures are only applicable to non-serious offenses or to a first-time offender. But Natasha showed us that some countries in that region, Eastern and Southern Africa, do have and have successful practices for serious offending and as well as repeat offending. She also mentioned to us that, these countries are not high-income countries. The same study that was shown to us this morning in the Asia Oceania workshop with Professor Ved and in a similar ASEAN study, that the maturity of a child justice system / juvenile justice system does not depend on the income. It doesn't have a one-to-one correspondence with the higher the income, the more mature. In fact, those who are lower middle-income countries can, as much as possible, also have promising practices on restorative justice and non-custodial measures and diversion, if there is political will, as you said, and the way we value our children. Finally, just that denomination of diversion from the formal justice system. But if diversion is not allowed, then that child should be able to access non-custodial measures across that continuum of justice system. So now we have done a little bit of a deep dive of the first. Don't worry, don't have to go to all the 10, because some of them, and most of them actually are correlating with each other. And so that you have something to read for later. Now we go to my colleague here, Mexico. And Maria Elisa is from a university in Mexico. How is Mexico promoting the participation and empowerment of children in the justice system, Melissa? I'm Maria Elisa.
Muchas gracias.
Well, thank you very much, and good evening, everyone. I'll be speaking in Spanish, but good afternoon to all of you anyway, she said in English. Mexico is a federation, so this is a question I could answer in two ways. Number one, the Supreme Court of Justice published a protocol which lays down how we should act when children enter the justice system. Its earliest version was published in 2011, then there was an updated version in 2012, and this protocol sets out some guidelines which truly place children at the center of it all. So that's the starting point as regards federal justice in Mexico. But there are two important experiences that I'd like to talk about at a local level, and I'd like to focus on this. There are 32 federal entities in Mexico, which equates to 32 opportunities to apply this federal protocol at a local level. And we already have two models which we believe are truly placing children at the center of it all. We have hearing rooms, which we call SAPCO, for people in situations of vulnerability, and dedicated rooms for children and teenagers. So these are dedicated procedures and hearing rooms for these groups of people. And they are physical rooms, there are physical buildings. We want children to go to a hearing in a separate room compared to adults, so that, for example, they don't have to face perpetrators or other offenders. So they have a separate entrance that they go through. They have a waiting room where they're accompanied not by the judge, but by a psychologist, a psychologist who helps children get ready for the hearing, but at the same time, through a camera, the judge can monitor, can oversee it all and make sure that the children are doing fine. So children psychologists, juvenile psychologists or pedagogists who basically coach the child ahead of the hearing. And this measure, we like it for several different reasons. Aside from the fact that, of course, it separates children from adult offenders and more serious offenders, it also tends to ensure that they don't become persistent offenders, because they're treated in a slightly different way anyway. We have currently about half of the American territory, which is working steadfastly towards adopting measures such as this, thanks to UNICEF, I should say. And it's been particularly well received by civil society. Well, thank you very much. I wasn't listening to the English translation.
For persons in vulnerable conditions in the criminal justice system, and the other one is the listening rooms for child and adolescent participation in family matters. She also spoke, Madam Maria Elisa, about the role of mental health and psychosocial support. She mentioned about the psychologists who are in this courtroom, but most importantly, the empowerment of children as they make their testimony, whether in family matters or in criminal matters. You mentioned about UNICEF helping you, and the Sociedad Civil, the civil society. But what also is the role of UNAM as an academic institution in this initiative?
Bueno, muchas gracias. Yo soy investigadora.
Well, thank you very much. I'm a researcher at the Autonomous Mexican University, which is a public university, the largest public university in the country. And we've signed with UNICEF a cooperation agreement which has allowed us to adopt this methodology in two ways. Number one, in research. We're looking at how models are being applied throughout the country to verify that it complies with the principle the protocol was written with, to actually see whether children are being listened to. And then we're also using it to create every 3 months, quarterly, spaces of dialogue with superior courts of justice to talk to one another, basically, and see how we can improve. Actually, the next meeting of this kind is coming up next week, and as always, we'll be talking about strides forward that we've made, challenges, and everything else. And so the university is a place of research, but also a place of encounter between civil society, academics, and victims.
Now said, the role of the university, the role of investigación in Español, the role of evidence, right? Evidence generation to show what works and what doesn't work. What are the areas for improvement? It doesn't work. What are the areas we can improve on? And that is very important in our good promising practices in our work in Justice for Children, to make sure to show the policymakers, the ones who hold the purse, that investing in these initiatives on justice for children really do make a difference, is cost-effective, and is promoting the best interests and the rights of children. Finally, Maria Elisa, you mentioned to us 9 estados, but how does Mexico plan to scale up these initiatives?
Muy bien, esa es una pregunta muy compleja en este momento de la historia de México.
Well, this is a very difficult question at this time in the history of Mexico, because we just approved a constitutional reform which dramatically impaired judicial power. Last Sunday, we held elections for national judges, and this in practice means that by 2027, when the reform will be fully implemented, almost 7,000 judges will be removed from their posts. What does this mean? That we have made a stride forward in terms of skill building judges so far, and all the progress we've made will be lost because they'll be removed from their posts. So this poses a huge problem from the point of view of human rights and from the point of view of our agenda as well in Mexico. So I'd like to take this opportunity to launch an appeal here, because we can't let justice for children to be forgotten. What is the issue? That children don't vote, and so they will hardly be placed at the center of the agendas of those judges who will be elected by popular vote. They won't be thinking of these children. And so the participation in the work carried out by civil society, by us alongside UNICEF and by the university, will all be put in jeopardy. But it is fundamental to ensure that in Mexico we guarantee fair access to justice to children and teenagers. Oh, thank you so much, Maria Elisa. I'm going to switch to English now.
And it's a challenge that all of us are facing. We do great things. One day, something might change. The political challenges are there. So what do we do? And it's great that Mexico has this study. You have the study showing the evidence, and any any politicians or any government people will be able to understand, hopefully, that the evidence there speaks for itself and that we make our policies based on evidence, right? And of course, we all know children do not vote, but their parents do. All of us here on this hall and all those who champion child rights do vote, and we should put it in the agenda of our politicians, of our leaders, so that come these different political changes, the commitment to our children are there. I know it's easier said than done, and thank you for that, hopefully inspiring us. And again, all of us can empathize with what Maria Elisa has mentioned. We have heard about these two special courts talking about criminal justice system and the other on family law. Now we move to Spain, and they will tell us, Dr. Eva Bajo, to talk about another specialized court, this time on violence against children. Dr. Eva, por favor, podéis contarnos un poco sobre estos cortes especializados.
Buenas tardes a todas.
Good evening, everyone. First off, I'd like to thank UNICEF, particularly Almudena, for giving us this opportunity to come here. This court, which is in Las Palmas de Gran Canaria and the Canary Islands, is dedicated to handle cases of adults attacking, in a way, violently children and teenagers. So this is a very court of this kind in Spain. This was it was created after the so-called Low-PB law. The Low-PB Act was passed at the hands of Thomas Martin, a magistrate who for a decade had been putting together mechanisms, tools and measures to enable children to basically face fair trials when they needed to be in court. It wasn't per se an adaptation of the justice system. It was a bit more than that. It was a bit more ambitious than that. Now, I'm a coroner, and as such, I've always thought that in courts we should have a specialized unit to handle the cases of children. So we created the first unit of this kind. There are better models out there, and we know that now, but we know that now. We know what sort of professionals we need when children are affected by somebody else's violence. And, well, they need a lot. They need a holistic appraisal of their health, psychological, of their biological health, of their social, psychosocial health as well. We always say that violence against children is a multifaceted phenomenon, and that's why we need a 360-degree vision of the issue. And it's important to go one step beyond and put that violence in its context, to understand its history, the family of the children, and so much more. And I'll try being brief and tell you a little bit about my experience. Number one, we've been trying to adapt spaces. Courtrooms are hostile to children, or at least they are perceived as such, and I think this was very well explained this morning. And so, together with the help of a team which specializes in neuroarchitecture, we have slightly renovated certain spaces, certain areas of our courts, so that they would be fit to receive children when they would have to come in for their arraignments and stuff like that. At my Legal Medicine Institute, we've also put together another space, which will soon open, the House of Children. We've called it Casa de la Infancia. And children from throughout the province of Las Palmas can come there and enjoy a child-friendly space which has been designed for them, tailored to them in terms of colors, noise, or absence thereof. I only have a few seconds left to go, sorry. In parallel, we've also put together a coordinated action protocol whereby we work, for example, with the armed forces and other agencies of the government. Why? 2, encourage people to report cases of violence against children. They are more widely reported today thanks to this, but also to do away with impunity. We have reduced impunity drastically compared with other similar systems in Europe. Just this morning, Thomas Martin was sharing figures about the reduction in discontinuing rates, which went from 47% anywhere else to 0.7%, and the sentencing rate is 94%. Okay, why is this happening? It is happening because we've now put together a very well-oiled machine that works and is able to correctly interpret evidence, analyze DNA and all of that. So we are very, very reliable in our conclusions basically now. This is just an overview, just a summary of what we have been doing, how we have been working and the results it's been yielding. Thank you so much, Dr. Eva. I want to follow up, but you've said it all really. You've already answered all of my questions. So I will cease and desist. I won't ask you any questions, but I do think that what you just talked about provided an example of how important it is to have a collaboration across different sectors. Healthcare, you're a doctor, justice and psychologists, neuro-architects, so much more. It's a multidisciplinary approach and it's great. And now I would like
approaches. We are also going to Bulgaria to talk about another model that they are using in Bulgaria, known as the Barnahus model. And we have with us Ms. Nelly from the Social Activities and Practices Institute. So it works now.
It works?
Yeah.
Okay. Thank you. Thank you to invite me. My name is Nelly Petrova. I'm chairperson of Social Activity and Practice Institute, which is a Bulgarian NGO, working many years with UNICEF and trying to develop integrated social services for children victims of crimes and violence. I am also professor of social work and social pedagogy at Sofia University, and we in our organization we try to have a link between theory, researches and practice. Our promise is practice, I tell you about. It's Zona Zakrila, it's mean protection zone in Bulgarian. This is the Bulgarian Barnahus model. We started many years ago with good practice, multidisciplinary practice, created a specialized hearing room, like a colleague was mentioned, and in the social services buildings. And in our practices, psychologists or pedagogue realize the interview for the justice system. They are with the child. They use international protocol for raising interview, and in the other rooms are police, prosecutor, judge, etc. It depends of the stage of the case. Using this practice, we with UNICEF in 2016 started, and our colleagues from Animus Foundation, we combine our expertise in juvenile justice our child-friendly justice and in the field of domestic violence from our colleagues, and to try to use Bulgarian situation and to adapt this model, Barnahus model, and we piloted free centers in 3 regions in Bulgaria. Now, after the pilot period, the project was evaluated as very successful from independent assessment, and now we try to develop this model in the other regions, because in this period the legislation, the legislative framework is changed, and now stimulate very well the multidisciplinary and multi-agency approach. And that's why we develop with UNICEF these centers in other 8 cities, using the social services system created in our country. And what we want to say, that in 2 of these cities we try to develop, we call this zone as a protection zone plus. It means that we will we will try to meet children in conflict with the law, with harmful behavior problems. Yes.
Thank you so much, Madam. I like it when you said you're linking theory and practice, and that's the point of our conversation today, that we show how these practices are done in different parts in different regions, in different countries in the world, and in different situations and contexts. Let me go to our last panelist before we open the floor to all of you for your questions. We have it here Ms. Lucia Lobato, as I've mentioned, the former Minister of Justice in Timor-Leste, and she will talk about the other parts that we have not mentioned yet in this panel. It's more about the legal aid and I think the legal empowerment work that Timor-Leste, well, it was discussed in some, but also they're doing a lot on legal empowerment and legal aid in Timor-Leste. Madam Lucia.
Thank you for the opportunity. Good afternoon, everybody, dear colleagues. I think that as a very young nation, we have a little experience to share with all of you. But I think that this forum is very important for us to share our experience and learning from all the experience of other countries. But let me say that now we are proceeding with the legal and judiciary reform of Timor-Leste. This is the very important program of the government, and we have a Ministry of Justice that the Ministry of that has this competence. But beside on that, the Prime Minister decided to create a very small group within the office of the Prime Minister, and now I'm leading this group. With the help of UNDP, we conduct a very systematic diagnostic about our legal and judiciary system. After the diagnostic, we came out with some very important recommendations. Now the government took these recommendations to start implement the legal and judicial reform of Timor-Leste. Let's say we find 3 main obstacles or 3 main problems related to the issue we just discussed. One of them is institutionally, our court need to be reinforced. Legally, we need more laws. We need to, how can you say in English? I speak a very poor English, so I hope that you can understand my English. We have a lot of laws that need to be reviewed, besides of approve new laws. Access to justice is still very difficult to reach to all the countries, because we only have 4 tribunal, the first instance, 4 for all the country, and we only have 1 high court that now that we call Tribunal Recurso, has the competence of the Supreme Tribunal of Justice. So we want to expand more that, because if we are talking about access to justice, we need to go to the people and not just in the city, just like say. But the most important difficult that we found is about human resources itself. We have some good laws, we have our courts there, we have professionals in that area, but with a very limited human resources. One of them is it's about where we are talking about legal aid professionals. We have in Timor-Leste has what we call public defenders, created by Antayed at that time, and now we continue with that institution. The government fund all the expenses of the defender, the public defender office, funded by the government, and we spend a lot of money for that. Maybe they get around 1 to 3 million a year, and they spend for all the activities. We have a very limited number of public defenders, only 34. Therefore, the government decided to fund some NGOs with a specific specialization in areas that dealing with children rights there. So the government fund everything. Fund the private lawyers also, we hired some of them. So need to do more to support our professionals there. So only 34, you can imagine for all the country. But in some good results that we found, let me explain, always represented, all children, adults, always represented. A child or a juvenile accused of a crime is supported by legal professional in all the stages of the proceedings. This is a very good sign. That we have a very young legal judiciary system, but this is the guarantee by the state. Children in prison. I heard today, thousands of children in jail. Timor-Leste, in 2023, we only have 1 with 70 years old in pre-detained, how can you call, pre-trial detention, 2023. In 2024, also just 1. But I acknowledge that we should have none. Children now, they are speaking up when they are victims of crimes, and families are believing them. Because this is a big challenge from the last 10 years. Modern school curriculum since 2015, increase access to information from online sources, as well as many awareness raising sessions in the community. So this is what we have now in Timor-Leste. But we are still talking about how to reform the system, how to support the legal aid, specifically for the children's rights.
Thank you, Madam. I think she mentioned, the child-friendly legal aid, how governments also support the private sector the private lawyers, they fund the public defenders and NGOs to be able to serve its citizens and at all stages of the proceedings. I've been to Timor-Leste many years ago, and I know they have one of the highest minimum age of criminal responsibility, which is 16. And I remember Mr. Horta saying that why will we put, we don't have a lot of resources aside from the rights perspective, but, it is more costly that we build all these facilities. The right intervention is to make sure that it's a community-based approach and to make it as high as possible so that you don't manage these jails, which are not effective and very costly. Thank you very much, Madam Lucia. And now, with the 7 minutes that are remaining from you, for all of you, if in case you have questions to any of the panelists to ask about these advocacy briefs, this is going to be available, your souvenir postcard at the back. It's and also a report card that Shima mentioned. It's available in Spanish and English. It's also at the back. And you can get our QR code, but it's also going to be in a postcard. Are there any questions, burning questions, to any of the panelists to ask in any of our global products? Yes, ma'am. Sorry. Ay, perdón.
All right. So I have a question to the lady from Bulgaria about the Barnahus model. And you mentioned that you have currently three units. And you intend to bring it to scale, right? To introduce it in 8 other cities. I would like to ask, how is your how is this model financed? Is it permanent? Are these 3 units permanent, meaning run by government or by SGO? And what are main challenges in bringing these Barnahus houses to scale? You have 3. I understand this is like a pilot, and then you want to make it more. So what challenges and how do you go about financing?
Okay, thank you.
Yes, ma'am.
Thank you very much for these questions. In the pilot phases, UNICEF financed the centers. They are centers, not houses, like Barnahus. And we provide forensic interview, informing for child rights in the different proceeding, therapy, medical accompaniment to go, because we have not this kind of activities. After that, we achieve sustainability of these 3 centers as a social services, because in Bulgaria social services are funded by the budget, but they are in the competency of the local authorities, and local authorities can provide the services, but also they can by concourse delegate them to the NGO, and in this manner we as NGO we are service provider many years ago, yes, and now because we have relatively new Social Service Act, when they try to introduce the integrated approach. And it means that we as service providers, we absolutely obligated to provide integrated services with other sectors. And we, with UNICEF, we use this and with lobbying with government, and all these 3 centers are financed now by the state budget. This was the idea, because in these new cities, in the social services building, we created a REPOC Blue Room, specialized room for child caring, and now we use this practice to develop other activities, counseling, psychological therapy, because this is the social services for children at risk and their family. And it means that all this activity exists, but the team have to coordinate the multidisciplinary work in the casework, in the case management, to do all in the individual approach. Yes, the challenges are the same, like colleagues mentioned, the capacity of the people to train them more. Yes, this is the big challenges we think. Yes, if you are interested, tomorrow we have a workshop for this.
Also on that note, we have, again, in UNICEF documented different models of multidisciplinary practices around the world, one of which is Barnahus. In some countries, you call it the Child Advocacy Center. In Asia, we call it the Child Protection Unit. So we can add that in your repository of materials. We launched it earlier. This is a documentation of the different multidisciplinary practices that exist. Thank you, Madam. Anyone else? Okay, now they have more.
Thank you. I wanted to thank you for the interesting session and the promising practices. I had a question a little bit about the number of children that you mentioned, deprived of liberty in the administration of justice. Whether you could tell us a little bit more, does this also include like children in pre-trial detention, like which children are included? And did you also consider data from, like apart from the data submitted by the states, the countries themselves, did you also consider data by other actors, like NGO actors, other actors? Thank you.
Correct. Madam, I will... Otra pregunta y acabamos con esto.
Hello. I'm Valerie Khan from Pakistan, and the country has just launched in December 2024 a Reimagine Justice for Children in Pakistan program based on the global agenda. So we're really in the baby step to initiate that. We're doing that in collaboration with civil society, a technical partner, and UNICEF. But my question was, have you faced the following challenge? You know, when we talk about alternatives to detention, or alternative measure and trying to keep children away from the court processes, at least in Pakistan, we face a kind of a positive feedback saying, yes, there are children for sure, but then they immediately somehow propose another form of institutionalization, you know, maybe not detention, but another form of institutionalization. And we are really hitting big walls to tell them, listen, if we talk probation, if we talk diversion, it has to be done into open environment. Have you faced the same difficulties? And if yes, how have you overcome that over-reliance on institutionalizations whenever there is a problem with children?
Thank you. Those are two last questions, but I'm sure you have more and you can reach out with us. On the data, we include children in pre-trial detention and until post-trial detention. So it's administration of justice, yes, not immigration detention, not national security, not the other forms of detention, as we know in the UN Global Study. Second, it's based on administrative data. So also we have to compare the countries who have data year in, year out. So that's the challenge. As Shima was mentioning, it's the tip of the iceberg because some countries might have data but for only 1 year. Then you cannot compare. So that's why that's our call as well, to encourage governments to report regularly and to not be ashamed of reporting. There's nothing wrong with reporting. As a matter of fact, you're looking at yourself, self-reflecting. So I think that's the messaging as well, that we have to tell governments. You won't know until you have the data, if your policies are really impacting on children. Second, yes, in the UN study, we define detention as defined in deprivation of liberty. Any form of detention by judicial or administrative order where they cannot live at will. This is not a UNICEF invention. It's according to international standards, as we all know. And yes, you can call it by any other name, a youth rehabilitation center, a youth reception center. You can make it a nicer version of the jail, but it's still institutionalization. So no, we don't tolerate those kinds of... Of course, we say, when you have, say, no detention, what does it mean? Of course, baby steps. If you say no to jail, as one government would say, we make sure that we are there all the time, Reimagine Justice, to make sure that they don't start constructing big educational facilities and show the evidence that community-based is more effective and less costly. So that's how the advocacy hopefully will tell you that it's economically correct, it's not just according to international standards, and that we have evidence that when you do community-based diversion, you reduce reoffending by at least 70%. So we have in this paper that definition of what we mean by deprivation of liberty, the rights, the economic, the costing of why it's more important to invest in community-based. Madam Moderator.
Muchas gracias a las ponentes. Un aplauso para todas ellas.
Solamente, muchas gracias. Espero que, perdón. I hope this is just the start. We will give you the contact persons, and you can also reach out to Shima and me of all the documented practices here. I hope you're still excited to read them after listening to us. Very much excited. And before you go, please get this at the back, and if you want to share it to your friends who did not come here, yes, you can share it with them, and you can bring to your respective countries.
Gracias, Grace. Gracias a todas las ponentes.
Thank you very much to all the speakers. You have shown us that changes are possible. And now we will give the floor to the Executive Director of UNICEF Spain, José María Vera. He's going to conclude this session.
Muy bien, pues muchas gracias.
Thank you, Lucia, and thank you to all of our speakers. The only man here, and I'll be doing the closing. I think I'm severely outnumbered here. There's hardly any men in the audience as well. And that means something, I'm sure. Thank you, Blanca, and thank you, Joanna, for the support of Sweden and the support of Spain in the context of this program aimed at supporting children. I think you've done great work in trying to attract new partners here, and the more partners, the more members, the better it will be. Sheena touched upon 3 pillars. She talked about the importance of data, evidence. They point to a slight improvement, but still, it is unacceptable where we are at. Those numbers should be 0, all of them, when it comes to the deprivation of freedom. And that large unknown space, that dark space where countries struggle to collect reliable data. We've heard about a lot of model reforms. We heard a lot of advocacy briefs, the common policies coming down to us from UN agencies. They are a great way, really, to support other actors, other players, and all the examples we heard about today are fully backed by experience. They work, and I think you all touched upon the idea of skill building. That also seems very important. Lots of experience then, all of them very enriching, all of them successful. They show how important it is to steer children away from becoming victims twice, what we called re-victimization. We talked about the importance of adapting justice to children, but better yet, creating a new justice system. And we talked about the alternatives we have, because there is a way forward. And the way forward is placing children at the center of it all. And to conclude, I just wanted to say that I feel like we're all part of a community of countries and institutions committed to reducing to 0 the number of children deprived of their liberty, and committed to creating a justice system that is truly protective of our children. Thank you very much for your attention again.
Thank you.
Muchísimas gracias a todas.
Well, thank you very much, everybody, and thank you to all the participants. Thank you.